Talking to Wesley Keeny about Coida claims. Maybe we can first ask you, what does Coida stand for?
Coida is the Compensation for Occupational Injuries and Diseases Act.
And what in principle does this entail? When can you institute a Coida claim? It relates to an employee, is that right?
Yes, yeah. So I mean, it's the commonly known as workman's compensation claims. That was the historic name that was utilized. So essentially, if an employee meets with an accident, and an accident is defined as either an injury or occupational disease, which arose out of and in the course of employment, then they potentially have a claim for compensation.
Sounds simple, but it's not always that simple. If we can maybe take a couple of examples. If you trip over a chair at your place of work and you break your arm and the medical expenses, etc., would that, for example, be a case where you probably would succeed with a claim?
Yes, I mean, I would think it's a risk inherent in the workplace environment, so you'll probably have a claim there. The extent of the compensation is another question, but you would have a claim.
Mine worker who's injured in a lift that malfunctions underground, I guess no question that would also.
Absolutely. I mean, the facts that you propose regarding a malfunctioning lift actually suggest potential increased compensation, which is something which we can talk about as well. But you would have a normal claim, sure, possibly a claim for increased compensation.
Someone who is not healthy and has a heart attack whilst at work.
That's difficult. It all depends. I mean, it's again conceivable that in a certain set of facts there might be a stressor or an event which triggers the heart attack, and then so without the stressor, the heart attack wouldn't have happened. But there are other instances, obviously, where the heart attack just happened without any stressor. They're not exerting themselves at work or anything like that. Just happen to have the heart attack. It's then, I suppose, quite difficult to say whether or not that arose, out of employment. It's not risk inherent. It would have happened if they were at home, conceivably. So unfortunately, it's always factual. It all depends on the facts of the matter, and to a very, very large extent, the medical evidence is very, very important. The opinions of doctors.
Causation. Now, what caused the disease or the accident?
Exactly. Yeah. So one of the definitions that use the word result in. So it must be there must be causation. So the workplace environment must cause the accident.
I guess there are a lot of court cases about this where parties can't agree as to whether there is a valid Coida claim or not. Can you give me one or two examples?
Well, there's not a huge amount of case law because by and large gets resolved internally with the compensation fund. So most cases are sifted through the appeal or the objection process in terms of the act. But there are cases where it does come up. For instance, and a lot of the cases was obviously before the Compensation Act came into effect, so it was the old Workmen's Comp Act, but the principles are obviously apply. So for instance, there's Standard Bank versus Ralph, where an employee was actually had left work for the day and then got to the elevator where the accident occurred. The question then is now, where does your work start and end in that matter, because they were still essentially on the work premises almost that entered a common area, but the court found that there was no liability in that instance. There was another fairly old case as well where if my recollection is correct, it was around about the during the apartheid era, because there was what was then defined as acts of terrorism, and employees were they were busy working, and then something happened. I can't remember the exact. It was an explosion or something to that effect, and the court still found that they were liable because the employer brought them within the realm of that risk, and even though one would normally say that an act of terrorism, as it was phrased at that stage, wouldn't be regarded as a risk inherent in employment. In the social political circumstances at that stage, the court said it was allowed. But again, it always depends on the case.
Let's say someone during a lunch break walks to the shop to buy some food, etc.
In my opinion, no. That wouldn't be, because you're no longer furthering the interests of the employer at that stage. So, for instance, I mean, even if you were, say, doing a work errand for your employer, and you decide you want to quickly run a private errand, and if the accident happens whilst running the private errand, say you're going to pick up a child, whatever it may well be, then there's no longer a link between the employment and the accident, and then liability, in all likelihood, again, it all depends on the facts, but in all likelihood, wouldn't arise.
Was there not a rape case a couple of years ago as well, where there was also a question as to whether that's work-related or not?
Yes, it more deals with the definition of arose out of. So again, an accident must be in the course of and arise out of. And arise out of has, I suppose, an oversimplification to say, but it must be a risk inherent in the employment. So in this case, there was a nurse in the Free State. It was after hours, and from what I can gather from the set of the facts, she was walking between two buildings, and she was raped. Then when she sued the Department of Health, as her employer, saying that they've got an obligation to make sure that the work environment is safe, etc. They raised Coida, these employers' liability under Coida, exclusion of liability under Coida as a defence, and the court said, but listen, it can't be that it's a risk inherent in employment that an employee will be raped.
Why do we have this Coida fund, do you think? What was the idea of the legislator? I guess it's to protect employers and employees and to give them that sort of insurance that if something happens, which is work-related, etc., then at least there will be compensation available.
Yes, well, it's a form of social insurance. Okay, and there's a very nice case in the constitutional decision by Judge Iku, which details the reasoning behind Coida. But essentially, what it entails is it's a system whereby employees are essentially guaranteed the ability to recover compensation payment for workplace accidents, because at common law, which would apply, you would need to prove that the employer was negligent, for instance, or at fault, which is at times very, very difficult to prove, and obviously a costly exercise for many, many employees. And even if you are successful, there's always the risk that the employer will not be able to pay you. So that's where the social insurance comes into play. It's a form of no-fault liability. So the employee need not prove any negligence on the part of the employer. So it can happen due to a normal accident, as one would define it, unforeseeable event. You still have a claim, which is obviously quite nice for employees.
Yeah, that I guess helps a lot, because I mean a lot of cases falter when you have to prove fault, negligence, or sometimes even intention. So in this case, they don't have to prove that, and then the employees do have that compensation that they can claim. What can they claim? Can they claim medical expenses that they have? Can they claim for pain and suffering? Can they claim for loss of income?
Well, that's unfortunately the trade-off that you have with a form of social insurance. The trade-off being that your claim in terms of the Act is far limited compared to what you would have at common law in terms of damage claim against the employer. Again, this is the Constitutional Court case that I mentioned. Score Supermarket versus Jooste, or Jooste versus Score Supermarket. I forget which one, or which name comes first. But essentially, what you're entitled to is compensation in terms of the Act. So it's not damages. It's a completely different concept. So stuff such as pain and suffering that you mentioned, for instance, that's a damages idea. It doesn't form part of compensation. In terms of compensation, you're compensated in relation to your accident earnings, so with view of your accident earnings, with a statutory ceiling. Okay, so high income earners, they aren't assessed in terms of the compensation in terms of what they were actually earning. They'll be in terms of the statutory ceiling. And then there are various types of compensation that's payable. We have three kinds essentially, but only two really are of relevance. We have what we call TTDs, which is temporary total disablement. So temporarily, you're totally disabled to do your work. Okay. So for instance, in your example that you utilize, say you broke an arm, for instance, temporary. I mean, that's a temporary issue. Your bone should obviously heal and repair, but you're totally disabled to do your work, but only on a temporary basis. Then you're entitled to TTDs, which is 75% of your accident earnings, obviously subject to the ceiling, and obviously medical assistance as well. If, however, you suffer what they call PD, permanent disability, okay, then you're entitled to different type of compensation. So you're entitled to PD when you reach what they call MMI, which is maximum medical improvement. So essentially when you become stabilized. Obviously, you can't assess somebody on day one because it's not going to be a true reflection of where they will be in the long term. So once MMI is reached, and normally it's not less than 3 months, the fund normally waits at least 3 months. It's obviously in many cases it goes much further. The Act actually caters for a 24-month period. So essentially after 24 months, there's a presumption that where you are at 24 months is where you're going to be, and then you determine to be permanently disabled. So it's a different assessment entirely. And there's a different formula as well. So up until you get PD, permanent disability, you get your TTDs, which is 75% of your accident earnings, and then your PD comes in where if you are assessed to be more than 30%, so essentially 31% and above, you get a pension. You're entitled to a pension, and then obviously there are the medical costs, to an extent paid. Normally only for about 24 months, but the fund can continue to pay certain medical costs if it can be used to relieve the extent of the injury.
So let's say you can still also prove your common law claim against the employer. Let's say the employer was negligent. Let's take that lift that had a problem in the mine and there was an accident, and it can be proven that the employer was negligent. Can you then still claim anything from the employer if you're looking at the damages as opposed to just the compensation, as you now said, which might give you an extra amount?
No, unfortunately not. Your common law liability.
Unfortunately for the employee.
Well, unfortunately for the employee. Well, it depends on the set of the facts. Sometimes, unfortunately, other times it is fortunate. Like I said, sometimes difficult to prove. But yes, the employer's liability is excluded under Section 35. So the common liability is excluded. You don't have a claim against the employer.
So that's the good news for the employer. He's sort of protected.
That's correct, yeah.
There's insurance for the employee and he will be compensated according to those criteria that you mentioned now, but he can also not be sued then in those circumstances.
Yeah, so he will just raise Section 35 as a defence, say that his common law liability is excluded. The question then arises, does the Coida apply? You might have a set of facts, for instance, where it's not clearly apparent if Coida applies. I have a case, for instance, at the moment where a person was involved in a robbery. He was an employee. He was one of the employees of a truck. The truck was robbed, and he was actually shot. He now issued a claim against the employer. So we've obviously utilised the statutory exclusion of liability. So the argument is whether or not it is Coida related.
Maybe just briefly touching on COVID-19 as well. If you can prove that you contracted COVID-19 at your place of work, would you then also have a Coida claim in principle?
In principle, yes. Okay, so we've spoken predominantly about injuries now, so physical injuries. You also have claims for occupational diseases. Now, an occupational disease is not, there's not a closed list of occupational diseases. There is a schedule, Schedule 3, which names a number of occupational diseases. All that really relates to is if you suffer from one of those diseases, it's presumed that it arose out of in the course of employment. So then you don't have to prove that whole causal element. For COVID-19, it will be regarded as again, conceivably an occupational disease. You would just make sure that it was acquired, or prove that it was acquired in the workplace environment. So it's not a Schedule 3 disease, so the presumption doesn't apply. So there are certain triggers and certain things you need to prove when lodging a claim, but you do have a claim for, again, potentially for COVID, provided you can show that it was contracted in the workplace, and you normally do that. There was regulations published right at the beginning of the pandemic, where you just need to show that there was somebody who had tested positive in the workplace environment. That would ordinarily suffice, or if you're in a high-risk environment. So they were talking about, for instance, healthcare workers who are subject to, I think the terminology is like aerosol triggers, which is where coughing or and stuff like that. They will be regarded as a high-risk environment. So if you can show, for instance, that you're a nurse working in a hospital ward, where people are coughing, that's a high-risk environment, and there will probably be a presumption in your favour that it is, you're contracted it in terms of your employment. Other circumstances are obviously low risk. Then it's more difficult to prove. You then have to prove that there was somebody in the workplace, who had it before you, and then I suppose you've got that link, and you'll be able to say that I contracted in the scope of my employment. Then the question always arises again, what are you entitled to? Ordinarily, most people recover fully from COVID. So for so long as you are off, you can get your TTDs. The regulation limits it to 30 days. I have my doubts as to whether or not that is a valid regulation in that regard. The Act caters for so long as you are temporarily totally disabled, up to a period of 24 months, you can get compensation. But you can get your TTDs, and then if you don't recover, then obviously So if there's a long-term impairment, the fund would assess that impairment in relation to the Coida, and then obviously pay out your PD, the permanent disability that I mentioned. And likewise, obviously, if it leads to death, if you pass away as a consequence of occupationally acquired COVID, then your dependents would be entitled to compensation in terms of the Act.
Maybe just finally some practical advice. So what would you say any employee should keep in mind? The fact that if you get injured at your place of work or contracted disease at your place of work, then you have this claim that you can lodge and you can actually do it yourself. You don't have to use an attorney.
Yes. The employer is obligated to report an accident. Okay, and when you use the accidents, it's both a physical injury and occupational disease. So an employer is obligated to report it to the fund. If they don't report it to the fund, it's a criminal offence. But the reporting, I've come across almost no case law or cases practically where the employer doesn't report it. They report it, and along with the reporting, there's a claim for compensation which is lodged on behalf of the employee. It's a fairly simple process. Like I said, you submit it to the fund.
So employee actually lodges on the place of, or for the employee.
Yeah, so they normally use like a combined form, which is both the reporting of the accident, that's normally the physical accident, the reporting of the occupational disease normally is a separate report, and then the claim for compensation, normally they go hand in hand. The employer tends to submit it, but the employer's obligation is only to report the accident. The employee is supposed to actually claim compensation, but they use a combined form, so it normally goes hand in hand. Very, very simple. Like I've said, you submit it online. There's an online portal. The processing takes a while, unfortunately.
How long? Any idea? You never know with government.
Yeah, unfortunately, you never know. I mean, it all depends on. Sometimes the matter is fairly complex, which makes life very difficult for them, to assess. There might even be a dispute between the employer and the employee as to whether or not the accident actually arose out of employment. We see that every once in a while. The employer might say, no, it didn't happen here, it happened elsewhere. But yeah, the investigation must take place from the fund. The fund, as we know, is overworked. There's lots of financial burdens placed upon them. So, in my experience, to try and get feedback from the fund, it can take years.
Okay. All right. Thank you, Wesley.